And I walked down to my own dock one Saturday morning with a cup of coffee in my hand, and there was a stranger sitting in my Adirondack chair, a man I had never seen before, boots off, feet propped up on my dock railing, watching the sunrise over my lake like he owned every inch of it. He turned around slow, didn't even look embarrassed. He said, "Oh, Diane said this area was community property now." I had a deed, a survey, a legal description that put that exact piece of ground, that dock, that beach strip, that 30 feet of lakefront, exclusively in my name. Spoiler, I went with both. Before I walk you through exactly what happened, and trust me, it gets so much worse before it gets better. If you are new here, this is HOA Shield. We document every power play, every paper trail, and every Karen who thought the rules only applied to everyone else. Hit subscribe and tap that bell, because the story I'm about to tell you is one of the most calculated property grabs I have ever personally experienced, and the way it unraveled is deeply satisfying. My name is Marcus Webb, and I spent 3 years saving for that property. Clearwater Estates is a planned community built around a man-made lake in the eastern suburbs, the kind of place that looks beautiful in the brochure and turns out to have a homeowners association that takes itself more seriously than the federal government. When I bought my house, I paid a significant premium specifically for the lot, Lot 14. The deed was explicit. The property extended to include a 30-foot lakefront easement, my dock, my beach strip, my access. I had it surveyed before closing. I have the stakes in the ground photos. I have the title company paperwork. I got home from work to find a white envelope tucked in my door, that signature pastel HOA stationery with the little anchor logo on the letterhead. Clearwater Estates Community Association. I opened it and read, "Dear Mr. Webb, pursuant to Amendment 7C of the Clearwater Estates Community Use Policy, the Lakeshore Buffer Zone running parallel to lots 12 through 16 has been reclassified as a shared community access corridor." I read it 3 times. Then I went to my desk, pulled out my deed, and read that 3 times. There was 0 language in my deed, 0, that gave the HOA authority to reclassify any portion of my deeded property as a community access corridor. I emailed Diane the next morning. I kept it simple. "Could you please send me a copy of Amendment 7C, the meeting minutes where it was approved, and the legal basis for the reclassification?" Standard stuff, totally reasonable. She replied 4 days later. Her response was 3 sentences. It said the amendment had been passed at the February board meeting, which, by the way, I never received notice of, and that the HOA was acting within its governing authority, and that she'd be happy to schedule a call to walk me through the new guidelines. I did not schedule a call. Instead, I started a folder on my desktop. I labeled it Evidence. 2 weeks later, the first weekend of May, I walked down to my lakefront and found the stranger in my chair again, Diane's cousin. His name, I would later learn, was Greg Holloway. He had an ice chest. He had a fishing rod in my dock holder. He had the casual, comfortable energy of a man who had been told repeatedly that there was nothing I could do about it. Told him politely but firmly that this was private property and I'd need him to pack up and leave. He said Diane told him I'd probably say that. I took a breath. I said, "You have a good morning," turned around, walked inside, and called a real estate attorney. Her name was Patricia Ames, and she'd spent 15 years doing exactly this kind of work. I emailed her my deed, the survey, the HOA notice, and Diane's email. She called me back the next day. Her first words were, "They cannot do this. An HOA can govern conduct. An HOA can enforce aesthetic standards. An HOA cannot unilaterally reclassify land that is deeded exclusively to a homeowner and give access to third parties. Period." She said, "You could fight this in court and win, but let's give them a chance to back down first." She drafted a cease and desist letter. It was 4 pages. It cited the recorded deed. It cited the survey. It cited the specific provisions of North Carolina real property law. It cited 2 case precedents, and it gave Diane Holloway and the Clearwater Estates HOA 30 days to formally rescind Amendment 7C as it applied to my property. I had the letter hand-delivered by courier to Diane's home address and to the HOA's registered office address. Her response came in 10 days, and it was not what Patricia had hoped for. The HOA board sent a formal letter, signed by all 5 board members, stating that Amendment 7C was valid, binding, and had been approved by a quorum. They further stated that my failure to comply constituted a violation, and they were levying a $250 fine with an additional $50 per day for ongoing non-compliance. There were 3 things wrong with that letter, and Patricia circled all 3 in red. First, no written notice to affected homeowners before the meeting. Second, a board quorum is not the same as a homeowner's supermajority. Third, they had fined me for failing to allow access to property they had no legal right to access. That wasn't a violation notice. That was extortion. Diane apparently did not enjoy that letter. She showed up at my door on a Saturday morning. I have a Ring camera. I have several Ring cameras. And I will tell you exactly how that conversation went, because it was recorded. She knocked. I opened the door. She was smiling, that particular HOA president smile that doesn't reach the eyes. She said, "Marcus, I think we've gotten off on the wrong foot here. My cousin Greg is a wonderful person and he's just looking for a place to enjoy the lake. You have so much space. It seems like you could be a little more neighborly." I said, "Diane, are you here in your capacity as HOA president or as Greg's family member?" She blinked. She said, "I'm here as a neighbor." I said, then I'd ask you to submit any further HOA communications in writing and to direct them to my attorney. Have a good day." I closed the door. She sent 4 more violation notices over the next 3 weeks. Alleged infractions included dock equipment not stored per community standards, failure to maintain community access pathway, and this one is my personal favorite, creating a hostile environment for community members attempting to access shared lake resources. That last one was because I had put up no trespassing signs on my property line stakes. Then I had a conversation with Patricia that changed everything. She said, "You know what ends this faster than any legal filing?" I asked what. She said, "A fence." Here's the thing about property rights. I had the absolute legal right to erect a fence along my surveyed property line. I hired a licensed fencing contractor. I had my surveyor come out and remark the stakes. Every measurement certified, every position documented. I pulled the correct permits from the county. All 3 of them, all approved, all on record. Every box checked, every form signed. No vulnerability left anywhere. And I built a 6-foot cedar privacy fence in a straight line from the corner of my lot down to the water's edge. Right, down, the middle. Greg arrived the Saturday after the fence went up. I watched from my back window. He stood at the fence for a long time. Then he walked along it to the water's edge. Then he walked back. Then he left. Diane filed an emergency injunction with the HOA to compel me to remove the fence. The county sided with me. Every permit was valid. Every measurement was certified. The HOA had no grounds. Their own attorney, this came out during the formal HOA dispute proceeding, quietly advised the board that Amendment 7C was unenforceable as applied to deeded lots. The meeting minutes showed a closed session discussion in which the HOA attorney said, from the official record, the association's position regarding Lot 14 is legally untenable. At the next annual homeowner meeting, 3 neighboring homeowners, including Sandra, brought a formal motion to censure the board president for misuse of authority and for using HOA resources to benefit a non-resident family member. The vote wasn't close. Diane resigned before the final tally was announced. Amendment 7. C was formally rescinded at that same meeting. Every fine they had levied against me, over $1,200 total, was voided and removed from my account. I still have the fence. Not because I need it, but every single morning when I walk out with my coffee and sit in that Adirondack chair and watch the sun come up over my dock, on my lakefront, on property that is mine and no one else's, I look at that fence and I feel something that is deeply, profoundly peaceful. Nobody is sitting in my chair. Nobody is touching my dock. And Diane Holloway is not the HOA president anymore. Justice isn't always loud. Sometimes it's a 6-foot cedar fence and a stack of permit approvals in a county database that no one can argue with. So let me ask you, what would you have done? Drop it in the comments. Subscribe to HOA Shield right now, ring that bell, and I'll see you in the next one.